All right, so this one is a big one that's been floating around. The quote unquote "Don't Say Gay" bill, which is abject nonsense from the start. I'm actually going to just read the bill and then touch on a couple of things that it does. Needless to say, none of what you're hearing about what the left is saying the bill does is true. It's all complete nonsense. So here we go. I'm just going to read the bill. An act relating to parental rights and education, amending S1001.42 FS, I assume for Florida schooling, requiring district school boards to adopt procedures that comport with certain provisions of law for notifying students' parents of specified information, requiring such procedures to reinforce the fundamental right of parents to make decisions regarding the upbringing and control of their children in a specified manner, prohibiting the procedures from prohibiting a parent from accessing certain records, providing construction, prohibiting a school district from adopting procedures or student support forms that prohibit school district personnel from notifying a parent about specified information or that encourage or have the effect of encouraging a student to withhold from a parent such information. Prohibiting school district personnel from discouraging or prohibiting parental notification and involvement in critical decisions affecting a student's mental, emotional, or physical well-being. Providing construction, prohibiting classroom discussion about sexual orientation or gender identity, quote unquote, in certain grade levels or in a specified manner. Requiring certain training developed or provided by a school district to adhere to standards established by the Department of Education. Requiring school districts to notify parents of health care services and provide parents the opportunity to consent or decline such services. Providing that a specified parental consent does not waive certain parental rights. Requiring school districts to provide parents with certain questionnaires or health screening forms and obtain parental permission before administering such questionnaires and forms. Requiring school districts to adopt certain procedures for resolving specified parental concerns. Requiring resolution within a specified time frame. Requiring the Commissioner of Education to appoint a special magistrate for unresolved concerns. Providing requirements for the special magistrate, requiring the State Board of Education to approve or reject with the special magistrate's recommendation within specified time frame. Requiring school districts to bear the costs of the special magistrate. Requiring the State Board of Education to adopt rules, providing requirements for such rules. Authorizing a parent to bring an action against the school district to obtain a declaratory judgment that a school district procedure or practice violates certain provisions of law. Providing for the additional award of injunctive relief, damages, and reasonable attorney fees and court costs to certain parents. Requiring school district to adopt policies to notify parents of certain rights. Providing construction, requiring the department to review and update as necessary specified materials by a certain date, providing an effective date. Being enacted by the legislature of the state of Florida, Section 1, Paragraph C is added to the subsection 8 of Section 101.42 Florida statutes to read 101.42 Powers and duties of district school board. The district school board, acting as a board, shall exercise all powers and perform all duties as listed below. 8. Student welfare. Charlie 1. In accordance with the rights of parents enumerated in SS 1002 decimals 20 and 1014 decimals 04, adopt procedures for notifying a student's parents if there is a change in the student's services or monitoring related to the student's mental, emotional, or physical health or well-being and the school's ability to provide a safe and supportive learning environment for the student. The procedures must reinforce the fundamental rights of parents to make decisions regarding the upbringing and control of their children by requiring school district personnel to encourage a student to discuss issues relating to his or her well-being with his or her parent or to facilitate discussion of the issue with the parent. The procedures may not prohibit parents from accessing any of their students' education and health records created, maintained, or used by the school district as required by Sierra.1002 decimal 22 2 parentheses. 2. A school district may not adopt procedures or student support forms that prohibit school district personnel from notifying a parent about his or her student's mental, emotional, or physical health or well-being, or a change in related services or monitoring, or that encourage or have the effect of encouraging a student to withhold from a parent any such information. School district personnel may not discourage or prohibit parental notification of and involvement in critical decisions affecting the student's mental, emotional, or physical health or well-being. This subparagraph does not prohibit a school district from adopting procedures that permit school personnel to withhold such information from a parent if a reasonably prudent person would believe that disclosure would result in abuse, abandonment, or neglect, as those terms are defined in Sierra 39.01. 3. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 in any manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. I'm going to read that part one more time because that's where all this nonsense is coming from. 3. Classroom instruction by school personnel or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. Number 4, student support services training developed or provided by a school district to school district personnel must adhere to student services guidelines, standards, and frameworks established by the Department of Education. At the beginning of the school year, each school district, this is number 5 now. At the beginning of the school year, each school district shall notify parents of each healthcare service offered at their student's school and the option to withhold consent or decline any specific service. Parental consent to a healthcare service does not waive the parent's right to access his or her student's educational or health records or to be notified about a change in his or her student's services or monitoring as provided by this paragraph. Number 5, again, this is a part of the nonsense. I'll read it again. At the beginning of the school year, each school district shall notify parents of each healthcare service offered at the student's school and the option to withhold consent or decline any specific service. Parental consent to healthcare service does not waive the parent's right to access his or her student's educational or health records or to be notified about a change in his or her student's services or monitoring as provided by this paragraph. Number 6, before administering a student well-being questionnaire or health screening form to a student in kindergarten through grade 3, specifically, the school district must provide the questionnaire or health screening form to the parent and obtain the permission of the parent. Number 7, each school district shall adopt procedures for a parent to notify the principal or his or her designee regarding concerns under this paragraph at his or her student's school and the process for resolving those concerns within 7 calendar days after notification by the parent. Provision A under number 7, at a minimum, the procedures must require that within 30 days after notification by the parent that the concern remains unresolved, the school district must either resolve the concern or provide a statement of the reasons for not resolving the concern. B, if a concern is not resolved by the school district, the parent may, subsection I, India, request the Commissioner of the Education to appoint a special magistrate who is a member of the Florida Bar in a good standing and who has at least 5 years' experience in administrative law. The special magistrate shall determine facts relating to the dispute over the school district procedure or practice, consider information provided by the school district, and render a recommendation decision for resolution in the State Board of Education within 30 days after receipt of the request by the parent. State Board of Education must approve or reject the recommended decision at its next regularly scheduled meeting that is more than 7 calendar days and no more than 30 days after the date the recommended decision is transmitted. The cost of the special magistrate shall be borne by the school district. The State Board of Education shall adopt rules, including forms, necessary to implement this subparagraph. II. Bring an action against the school district to obtain a declaratory judgment that the school district procedure or practice violates this paragraph and seek injunctive relief. A court may award damages and shall award reasonable attorney fees and court costs to a parent who receives declaratory or injunctive relief. Another subsection under II, Charlie. Each school district shall adopt policies to notify parents of the procedures required under this subparagraph. Delta, nothing contained in this subparagraph shall be construed to abridge or alter rights of actions or remedies in equity already existing under the common law or general law. Section 2, by 30 June 2023, the Department of Education shall review and update as necessary school counseling frameworks and standards, educator practices, and professional conduct policies or principles. and any other student services personnel guidelines, standards, or frameworks in accordance with the requirements of this act. Section 3, this act shall take effect July 1, 2022. That's the whole bill. So I would really like anyone who opposes this bill, who has actually read it, to explain to me how this outlaws saying the word gay, or it keeps students from being able to say that they have homosexual parents, or that the student feels like he or she is a boy or a girl opposite his or her gender, of which, of course, there are only two. That's abject nonsense. It says nothing about what students can say and what students can talk about. The only thing that the bill does, and this is the big talking point of the whole situation, the bill says that in grades kindergarten through 3, the school personnel can't instruct students on gender identity. That should be patently obvious to any reasonable person, and it is. The problem is the people that we're dealing with are not reasonable. Furthermore, the imbeciles who have read the bill and understand what's going on, but are choosing to lie about what the bill says, are pandering to an audience who don't care about the truth, obviously. If you support transgenderism, you objectively don't care about the truth. So it's no problem for them to spit out all this propaganda and nonsense about the quote-unquote don't say gay bill. The word homosexuality is never even used in the bill. It's talking about gender identity and the fact that school personnel can't indoctrinate children in kindergarten through 3rd grade, can instruct them about gender identity. And because this is a sweeping phenomenon we've seen all across the country, your teacher tries to indoctrinate your 6-year-old and convince him or her that he is the opposite gender or he's some other fantasy made up gender, and then the teacher doesn't tell the parents. Those are the only two things that the bill really does. It prevents kids that are, again, in kindergarten through 3rd grade. I was 9 years old in 3rd grade, or 8 maybe. So I was 5 in kindergarten, I was 8 or 9 in 3rd grade. That range of kids, it should be far broader, but for now, that range of kids can't be instructed about this nonsense made up gender identity by the school personnel. And the only other thing that the bill does is, if your teacher convinces your child that he or she is some other gender than what they objectively are, and the teacher decides not to tell you, that is now outlawed in the state of Florida. Pretty reasonable, pretty rational bill, and would have been seen as such if this was 15 years ago by literally everyone, with the exception of maybe someone who has some type of developmental disorder or personality disorder. The place that we're in now is that we've been completely overtaken by abject nonsense, and that's true when you have someone like AOC who has a platform. Like, the fact that a person like that even has a platform tells you where we are. All this bill does is protect your children from being sexually indoctrinated by the school personnel who are actively looking to do it. And it really tells you a lot about their motives based on their reaction to this bill. This bill doesn't do half the things that they say it does, but based on what the bill actually says, and the people who started all this nonsense know what the bill actually says, why are they in such opposition to the reality of the bill? That tells you everything you need to know about their motivations. The only thing that this bill does in reality that they find objectionable is it doesn't allow school board or school personnel to indoctrinate children kindergarten through grade 3 into their gender identity cult of nonsense. That tells you everything you need to know about their motivation. So I'm glad to see my next president, Lieutenant Commander DeSantis, making moves. DeSantis, hopefully, I'd like to see DeSantis elder 2024. That would be ideal. But if you object to this bill, I have not yet and cannot think of a rational argument that should raise any legitimate objection to this bill. This is a totally reasonable bill, And the fact that people oppose it tell you exactly what their motivations are. So I just wanted to actually read the bill because it seems like nobody has. So yeah, I hope that helped. If you haven't been wanting to take the time to actually read it, maybe you could listen to it here. It'll make a little bit more sense. But you've heard the entire bill. There's nothing I left out. Just read it word for word. So yeah, find the truth for yourself. It's not that difficult, especially with something like legislation that you can literally read on your own, and there's nothing else to it. So hope that helps somebody. All right, guys, have a good day.